Hello, my name is Gary McIndoe and I'm the Managing Partner at Latitude Law Solicitors. We have offices in Manchester, London and Brussels, and we've been providing specialist immigration and citizenship services to business and individual clients since 2007. I'm really pleased today to be speaking to you as part of the Mondaq Spotlighted Firms series.
Hello, my name is Keelin Claffey and I'm a solicitor at Latitude Law. With compliance demands becoming increasingly overwhelming for many businesses, what are the most common mistakes that employers make when applying for and managing their sponsor license, and what practical steps can they take to stay compliant with day-to-day management of the license and protect themselves against suspension or revocation? A common mistake that employers make when applying for a sponsor license is not providing all of the necessary information and documentation. It's very important that a prospective sponsor reads through the sponsor guidance and doesn't simply rely on the sponsor license application form to tell them what documents and information they need to provide. It's also an issue that if employers are not maintaining accurate records of their employees' personal contact details and work information. This includes things like their salary, their job title, and a job description. Delayed reporting is another issue that many sponsors face. There is an obligation on licensed sponsors to report certain changes to a migrant worker's circumstances or to their organization within a specified period of time. There are also often genuine vacancy issues when issuing certificates of sponsorship. It's very important that a certificate of sponsorship is only ever issued for a genuine vacancy within the business, and that this role has not been invented solely to facilitate a person's entry to or stay in the UK. Poor communication with employees is another issue that we see quite often. It's very important that an employer maintains regular communication with all of their employees, particularly their sponsored employees, just in case there's been any changes in their circumstances. Insufficient staff training is another issue we come across. Very often within businesses and organizations, there's no one within the business that knows how to use or navigate the sponsor management system, and it can become very overwhelming, so it's appropriate to seek assistance in those circumstances. A failure to stay updated on changes to the laws can be detrimental to a business, so it's very important that a business is familiar with changes to the UK's immigration rules, and very often these changes are reported within the sponsor management system, so it is recommended that a level 1 user log into the sponsor management system at least once a month to see if anything has been reported within the SMS. Financial instability can affect a lot of sponsor license holders. It's very important that a business is able to maintain its duties and pay its workers appropriately based on what was set out in their certificate of sponsorship. And finally, a lack of ongoing compliance checks. This can happen to businesses who perhaps become complacent after a sponsor license is granted and don't conduct audits to make sure that they are continuing to meet their sponsor license duties.
Hello, my name is Mohammed Hafejee. I'm a partner at Latitude Law. UK government's latest immigration reforms mark a decisive shift towards reducing net migration and favouring a high-skill, high-salary model. How will this impact employers, especially those in sectors like care, hospitality and construction that have traditionally relied heavily on an overseas workforce? The skilled worker visa reforms, which came into force on 22 July 2025, will have a major impact on employers in sectors such as construction, hospitality and care. One of the main changes is the increase in the skill level. So from 22 July 2025, the required skill level for skilled worker visas increased from Regulated Qualifications Framework, also short as RQF, Level 3, which is equivalent to A-level experience, to RQF Level 6, equivalent to degree level experience. As a result, over 100 roles have been removed from the skilled work occupations list. The impact of the increase of the skill level threshold to RQF Level 6 in the construction sector meant key roles such as bricklayers, carpenters, painters, welders have been removed from the skilled work occupations list. Although some construction roles are listed within the immigration salary list, previously known as the shortage occupation list, all immigration salary list occupation roles have a removal date of 31 December 2026. Therefore, it is uncertain whether employers in construction will be able to sponsor skilled migrant workers under these occupations after this date. The impact on the removal of construction roles for employers could result in project delays, increased cost and severe recruitment difficulties. In relation to the hospitality sector, the impact of the increase of the skill level threshold to RQF level 6 has meant roles such as chefs, restaurant or bar managers and kitchen supervisors can no longer be sponsored for skilled worker visas. The removal of these roles is likely to not only have an impact on employers within the hospitality sector, but it will also endanger high-end dining, tourism-driven restaurants and event caterers, many of which are filled with gaps with international talent. Another major change to the skilled worker changes is the increase of salary threshold. The minimum salary threshold has increased for skilled worker visas from $38,700 to $41,700. And the minimum salary rate has also increased for new entrants and roles which are listed on the immigration salary list from $30,960 to $33,400. The increase in salary thresholds for skilled worker sponsorships within construction and hospitality sectors will likely lead to increased costs for employers and potentially affect the availability of skilled labour in these industries. In terms of health and care worker visas, although the salary requirements have remained at $25,000 for care workers, a major impact following the changes post 22 July 2025 for employers in the care sector is the ban of overseas worker visas. However, care workers and senior care workers who are currently in the UK will be able to apply for permission to stay until 22 July 2028. And what are the impacts on employers? So firstly, there's increased cost. The increase in salary threshold for skilled worker sponsorship within construction and hospitality sectors will likely lead to increased costs for employers and potentially affect the availability of skilled labour in these industries. It will also cause difficulty in recruitment. The higher salary threshold could make it more challenging to recruit skilled workers from overseas, potentially worsening existing labour shortages in the construction sector. There's also potential for pay rises, which again will affect costs, so businesses may need to increase wages for existing skilled workers to meet the new thresholds, particularly in sectors where wages are generally lower. In regards to the focus on higher skilled roles, the shift to RQF level 6 requirements means employers will likely need to focus on recruiting for roles that require degree level qualification, potentially overlooking skilled workers with lower qualifications. And in conclusion, the reforms is likely to mark a fundamental shift away from reliance on lower skilled migrant labour in favour of a high skill, high wage model. While this may align with long-term objectives of upskilling and reducing net migration, the short-term impact for employers in care, hospitality and construction is likely to be severe, ranging from staffing crisis to operational disruptions and cost pressures.
I've been asked to talk to you today about the UK's immigration environment and whether it is still capable of attracting highly skilled and high net worth individuals. So this is of course two separate questions. So let's look first at highly skilled individuals. The 2025 Government White Paper on Immigration and the consequent amendments to the UK's immigration rules have a clear policy rationale: to raise minimum skill levels for sponsored work, in particular the skilled work visa route, which is the mainstay of the UK's economic migration regime. This has taken around 180 job titles or occupation codes out of the scope of sponsorship. So while some codes have been retained in two shortage occupation lists, currently for a time-limited period, the impact on employees and on employers is significant. Some sectors will be hit rather harder than others. For example, in catering and hospitality, it is no longer possible to engage new hires as chefs. While clearly requiring specialist skills, the ONS, or Office for National Statistics, classifies chefs as a maximum level 5 on the Regulated Qualifications Framework, or RQF, below the new cutoff at level 6, which is broadly degree level roles. So while a chef might only gain a diploma in the course of their formal education at catering college, it's the work experience that changes them from being a line chef to a master of their craft. There remains a possibility that additions could be made to the shortage occupation, or what's called the temporary shortage list in the immigration rules, as a result of reviews by government, or possibly the MAC, or the Migration Advisory Committee, which is an independent advisory body to the government. That could happen in the coming months, but the temporary shortage list is expressly short term. It's currently in play only until December 2026. There is no other way currently to argue exceptionality for someone in a standard occupation classification code below RQF level 6 at present. So it does really make it difficult for certain industries. One sponsored work route that does still retain recognition of qualifications below degree level is the service supplier route. This operates with reference to trade agreements that the UK has made with other countries or blocs, particularly the EU, under the EU withdrawal agreement, and with Australia. It's important to remember that this is not a visa that leads to permanent residence in the UK. They're granted with 1 or 2 years validity, and you're only allowed to spend 5 in any 6 years in the UK. You are allowed, however, to bring your dependents into the UK under this route. The route has quite a list of requirements. In particular, an applicant must have a contract to provide services to a UK company that are covered by a valid international trade agreement. They must be an employee of an overseas business or a self-employed independent service provider. They must meet relevant nationality or residence requirements under the relevant trade agreement. They must be providing services to a licensed Home Office sponsor here in the UK, and that company must issue the individual with a certificate of sponsorship in the service supplier route. They must also have worked for at least 12 months for either an overseas business or been self-employed in the same sector as the service they're going to provide in the UK for that period. So you'll see it's quite an onerous category. There's quite a lot going on with it, but it is a way to get around the degree level qualification threshold that has been introduced in the skilled worker route. So while the starting point in service supplier is a degree level qualification, there are exceptions. So notably for chefs, so chef de cuisine, they are required to have an advanced technical qualification plus at least 6 years experience. So that's a potential route for chefs to enter the UK, which up until now has not really been needed because they could enter under the skilled worker route. But now employers might well be looking at this option. There are other occupations as well which can potentially benefit. So, and this is a case we've acted on quite recently, technical testing and analysis. Engineers only require a relevant technical qualification. There's no, it doesn't specify that it has to be at degree level. And something we've not advised on, in fashion and modelling, no qualifications required. So, I mean, there are, of course, other sponsored routes which don't have degree level education as a requirement. Sports and creative sectors are the obvious examples of that. In those sectors, endorsement is based on achievement and the prominence in your field, rather than formal qualifications, as you might expect. It's a shame, really, that skilled worker doesn't allow for that level of discretion or kind of flexibility, but that's the way the skilled worker route is operating. So, continuing the conversation about highly skilled individuals, does the UK offer any unsponsored visa options? Well, the short answer is yes. Alongside the sponsored work regime, we have the UK's equivalent of the extraordinary ability visa that the US offers. And it's certainly gaining more traction, certainly in my practice, a lot more inquiries are focusing on this this UK option, which is known as Global Talent. So under this banner, individuals from a range of disciplines may apply either on a contracted researcher basis or on a peer review basis to enter the UK without sponsorship. The bar, as the name of the visa route, Global Talent, suggests, is set very high. In some fields, people at an early stage in their career may seek endorsements on an exceptional promise basis, but that's not available across the board. Global Talent is a good visa option because it offers accelerated settlement, offers you settlement after 3 years rather than the usual 5. So it's an attractive option if you're at the top of your game. Lastly, the UK recognises recent graduates of prestigious overseas universities in its high potential individual route. This is also unsponsored, so if you can afford to get a degree from Harvard, then this could be the option for you. It's not a route to permanent residence, it's a maximum of 3 years UK residence if you have a PhD from one of these listed prestigious universities, 2 years if you're bachelor's or master's, and you are allowed to bring your family with you under the high potential individual route. Next, let's take a look at the UK's options for high net worth individuals. The UK's potential visa routes are rather scattergun in this area. So we no longer have an investor visa, nor an entrepreneur visa, which is based on a minimum level of capital investment. Instead, business people with an innovative, viable and scalable concept may consider the innovator founder route. Like Global Talent, the UK Home Office contracts out an assessment process to a few specialist bodies, mostly seed funders, who offer a mandatory programme to entrepreneurs in which their business plan is dissected and developed, hopefully into a concept that matches the criteria required for endorsement. While there's no initial financial investment, innovator founders are required to put in the time and effort required to work through their chosen endorsing body's programme. This illustrates the fact that passive investment is no longer a passport to UK residence. The visa offers accelerated settlement routes, so 3 years to main applicants, but only if certain milestones are achieved by the business. These include confirmation that the applicant has shown significant achievement judged against the business plan that was assessed in their previous endorsement. And in addition, the applicant must meet at least 2 of a list of criteria when they're seeking settlement in this route. So these are that at least £50,000 has been invested into the business and actively spent furthering the business. The number of the business's customers has at least doubled within the most recent 3 years and are currently higher than the mean number of customers for other UK businesses offering comparable main products or services. It's a little bit niche, that one. Or the business has engaged in significant research and development activity and has applied for intellectual property protection in the UK, so that might include a patent, for example. Or the business has generated a minimum annual gross revenue of £1 million in the last full year covered by its accounts. Or it's generating a minimum annual gross revenue of £500,000 in the last full year covered by its accounts, with at least £100,000 of that £500,000 from exporting overseas. Or the business has created the equivalent of at least 10 full-time jobs for settled workers. Or it's created the equivalent of at least 5 full-time jobs for settled workers, each of which has a mean salary of at least £25,000 a year. So meeting 2 of those listed requirements gets you permanent residence after 3 years. We've acted for many clients who've achieved that in the 3 years. If you're not there after 3 years, you simply apply to extend your Innovator Founder visa and apply for settlement when you're ready to do so. So briefly, there might be a couple of other UK visa routes worthy of consideration for high net worth individuals. Expansion worker is It's a sponsored visa route which permits business owners, senior directors or staff in overseas companies to set up a UK branch or subsidiary. It's a complex visa and one that's subject to a lot of Home Office scrutiny. We're looking for evidence, for example, of the affordability of the UK expansion alongside a clear rationale for the move into the UK. Unlike the now closed sole representative route, there's no requirement that the main business stays outside the UK. There's no minimum shareholding requirements either, or maximum shareholding requirements I should say. So it has its advantages over the old sole representative, but it's not perfect by any means. It's also worth noting this isn't a route to settlement. So the way the rules are set up is you are expected to do 1 or possibly 2 years in the expansion worker route before switching over into the standard skilled worker route.